that impact personal injury recoveries. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, or your question isn't answered, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds. A trial lawyer's job isn't to know all the nuances of issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Payer Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare conditional payments, MAO plan liens, FEBA liens, all of those issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expert knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that's exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day.
Welcome to Synergy's Expert Roundtable on ERISA reimbursement claims. Today, we are bringing together members of our lien leadership team and also our experienced negotiators to answer some practical questions that plaintiff attorneys face when handling these reimbursement claims. So I am Teresa Kenyon. I'm the Vice President of the Lien Department here at Synergy, and I'll be serving as your host today. Joining me from our lien leadership team are Nikki Atkinson, Kevin James, and Jasmine Patel. And then throughout today's discussion, you're also going to hear from our experienced negotiators who really do work through these types of issues every single day. So my goal here is to keep this practical and conversational, really just posing questions that we often hear from our attorney clients here at Synergy when we do consults or when we just have regular conversations about the status of the lien claims that we are handling. So we're going to move through the questions, and then we're going to explain some legal framework, and we're going to share issues that we look for when we are evaluating and resolving an ERISA claim. Here on the screen are some of our Synergy team members. And from the top left, we have Ashley, and then we have Karis, Justin, Alejandro, Jennifer, Lena. And down at the bottom, we've got Mara, Laura, Morgan, Brenna, Jessica, and Laura. And they will be answering some of these questions today. Okay, so let's go ahead and get started, and let's begin with the foundation. So we're going to start with Jasmine. For someone who doesn't work on these claims every day, Jasmine, how is it that you would describe to them what ERISA is and why it actually matters in a personal injury case?
ERISA stands for the Employee Retirement Income Security Act of 1974. For our purpose today, it is what governs many employer-sponsored benefit plans, including health insurance plans. For plaintiff attorneys, ERISA usually becomes relevant when an employer-sponsored health plan pays medical expenses related to an injury and then seeks reimbursement from the client settlement.
Okay, so ERISA commonly applies to employer-sponsored health coverage, but that raises an important threshold question. So Jennifer, please walk us through this. Is every employer-sponsored health plan actually governed by ERISA?
No, not every employee-sponsored health plan falls under ERISA. While most private sector employer health plans are governed by ERISA, there are several important exceptions. This is going to be government-sponsored plans, such as those offered by federal, state, or local government employers, and there's church plans that are established by religious organizations are generally exempt from ERISA. Additionally, plans maintained solely to comply with workers' compensation, unemployment, or even disability laws are not subject to ERISA. Therefore, when evaluating a health plan, it is really important to confirm the type of employer sponsoring the coverage before assuming that ERISA applies.
So that distinction really matters because identifying the employer is only the first step. The next question is one that we hear quite often, and it's, are all ERISA plans automatically entitled to 100% reimbursement? Because that's what the subrogation vendor is telling me. So Lena, what should attorneys understand about that assertion?
When handling a self-funded ERISA file, the self-funded status does not automatically guarantee them full reimbursement rights. While self-funded plans generally are preempted by state law, their reimbursement rights are governed by their specific plan language. This would include the summary plan description and the master plan document. We would want to obtain those to review their reimbursement rights and recovery provisions. I did recently handle a file where the representative was refusing to reduce, stating that it was a self-funded ERISA and they did not have to reduce their lien. Once I obtained the master plan document, I was able to confirm that their recovery rights indicated that they would be reducing by attorney fees and case costs.
So the plan's funding structure is critical. And if it's self-funded, you need to look to the plan language. So Laura, said another way, do fully insured ERISA plans have the same reimbursement rights as self-funded ERISA plans?
So this is a question that we do get asked often. I've been doing this work for about, I don't know, over 2 decades now, and I still have attorneys that are unclear on the difference between fully insured and self-funded plans. So fully insured plans do not preempt state law. So whatever state that you are practicing law in, those rules would apply to a fully insured plan. So if they're required to reduce for fees and cost, then the health insurance lien is required to reduce for fees and cost. On self-funded plans, they are not required to do so and do not follow state laws at all. And this is due to the savings and deemer clauses.
Okay, so Laura mentioned the savings and deemer clauses, which are definitely central to understanding why state law might apply to one ERISA plan, but not to another. So Kevin, can you explain these clauses to us in more practical terms?
So the savings and deemer clause, they work together, but also independently, depending upon what type of health plan you're dealing with. So in short, we're going to take the savings clause first. In ERISA, we always talk about ERISA preemption, but it does not preempt every state law. Specifically, what they call the savings clause, ERISA contains a provision that any state law relating to insurance is not preempted by ERISA. This allows state regulation of ERISA fully insured plans through their insurance department. Where it gets interesting is how it reacts to the deemer clause. We call it the deemer clause because ERISA deems self-funded ERISA plans to be not be insurance. It basically just says it is not insurance. So that's why ERISA's fully insured plans and ERISA self-funded plans are treated differently. So in short, the savings clause saves from ERISA preemption any state law related to insurance, directly related to insurance. However, the deemer clause says ERISA self-funded files, however, are deemed to not be insurance. So they are able to preempt those insurance state laws. And so it all comes down to the funding status of the specific plan.
Now, this takes us back to the fact that we cannot analyze a lien correctly until we know how that plan is funded. So Alejandro, how can an attorney confirm whether a plan is self-funded or fully insured? What should they be looking at?
Yeah, so one way of making that determination is going to the summary plan description. Summary plan description typically includes a plan administrator information section. If you go to the slide over here to your left, you can find what a typical plan administrator section looks like. Here under plan administration, you see where it says self-funded. If you go down to source of benefits, it also says trust. Plan assets are held in one or more trusts. This is an indication that the plan is self-funded. Other times it might also say employer or employee, which is also an indication that the benefits are being paid through a self-funded plan. On the other hand, if you are looking at a fully insured plan, the type of language that you will find is what you see over here on the slide to your right. You won't find the typical plan administrator section in there, but you'll find something in the first few pages that says something along the lines of this first sentence here. Insurance or benefit administration is provided by or through Highmark Blue Shield. So it's telling us that the insurance is provided by the actual health plan. So this is the type of language that you'll find typically. You want to look in the first few pages for this type of language, which confirms the plan is fully insured. So another way of confirming a plan is self-funded is looking up the company's Form 5500. Here in the slide, you can see a company's Form 5500 under Section 9B. You can see where they checked 1 for insurance and 4 for general assets of the sponsor. If only insurance was checked here, that would be an indication that the plan is a fully insured plan. But since they've checked general assets as well, this is an indication that there are both fully insured and self-funded plans under this company. So what you would do next in this case is you would scroll down where you will find all of the plans that are under Schedule A. If you are to find a health plan under this Schedule A section, that could be an indication that the plan is still fully insured. If you do not find the health plan in this section of Schedule A plans, this is likely an indication that the plan is a self-funded plan.
So once the funding status is established, the next challenge is obtaining the documents that actually control the claim. So Nikki, what plan language should the attorney be requesting, and how do they make sure that they've received the right documents?
You'll want to start just by sending a request to the subrogation vendor directly, asking for any and all documents that they may have on file to support their recovery rights. When I'm sending a request, I like to request specific documents, including the SPD and or booklet, plan document, right plan document. Now, I know most often that these subrogation vendors aren't going to have all of those documents, but I do like to submit the request either way. Most often, they're going to be sending you the SPD or booklet because they don't have the other documents in-house. But from there, once you get documents back from the vendor, don't just assume that those documents are correct simply because they sent them to you. You'll want to kind of do some double checking of your own just to make sure that it's the correct document. And I normally go straight to that cover page and I'm looking for certain information. First thing I'm doing is comparing the effective date of the document to the date of accident or the dates of service that are included in the lien. So you'll want to make sure that you're looking at the plan language that was actually in effect when those claims were incurred. As an example, if the document is effective January 1st of 2025, but all the claims were from 2023, well, that 2025 document isn't the appropriate document to be reviewing. So you would push back on that. Another thing that I always check is, whether the documents match the client's actual coverage. So I will compare the, plan name, employer, or any other identifying information on the insurance card to the document that they provided. So if the insurance card says the client's coverage is Aetna Gold Plan, but the vendor has sent you a document that is for the Aetna Silver Plan, well, that's not the document that we would need. So you would push back to get that specific document for your client's coverage. And lastly, if you're dealing with an ERISA plan, you should be requesting the governing documents directly from the plan administrator. It's a formal document request under the ERISA statute 1024B4, which we'll talk about in the next slide in more detail. But that formal request and getting those documents from the plan directly gives you a much better chance of obtaining the complete and correct documents versus relying solely on the subrogation vendor.
Thank you for setting that up for us, Nikki, for the next question. So Kevin, let's talk 1024. So whether an attorney receives some documents from the subrogation vendor or not, the request still needs to go directly to the plan administrator. Can you walk us through how to make a proper request under 1024B for?
So a 1024B request can be a powerful tool in your inventory when you're dealing with ERISA self-funded plans specifically. 29 USC 1024B is the actual statute. And what it is you make a request upon the plan administrator themselves to produce the plan documents. The reason you want to do this is often the major vendors, they don't have all the documents in-house, and a lot of times they will send you whatever documentation they have, but often it's not the governing documents or all of them. And as you've probably heard before with ERISA plans, all of these documents often work together to actually define the plan terms, and they often use expansive, or they also use different terms to mean different or even the same thing. So it can be very confusing. So you want to make a request on the plan administrator directly. So you don't want to send it to Rawlings. You need to send it to like both the actual plan administrator, which you can get off the form 5500. And what that request does is puts the plan, gives them a time frame where they have to provide all the plan documents they have. Often we here at Synergy will get different plan documents from the plan administrator than what the vendors provided. We also often get more documentation, and usually that's the best way to get the actual governing documents, because Rawlings, Optum, they're going to try to send you whatever they all have on hand, which is often not the all of the documents, or even sometimes it's the incorrect documents, whether it's the wrong year or anything like that. In these requests, you do want to make them expansive about what you're asking for, because different plans call things different things. So you want to ask for, not only SPD and master plan, that's going to be what most plans will have, but you also want to ask about trust agreements, wrap documents, all these other things that can go into with these plans will name their various documents. So you want to be as expansive as possible. And it's important to note that it does not have to go out by registered mail, but you might want to consider it, because if the plan fails to respond, it can actually trigger financial penalties after 30 days if they have not responded. And those can increase over time. So just a little tip on 1024 is you want to make the request expansive in language, and you want to get it out as soon as possible. And you cannot really rely on what Rawlings or Optum, Machinify, or Conduit send you, because they often do not have all of the documents in the house.
Even after documents are produced, another problem still remains: determining what the document actually is and whether you have the right ones. So Ashley, how can you tell whether you have the governing plan document rather than just a summary plan description or some other kind of document?
So when we get into a file and we are requesting plan documents, the subrogation vendor will usually supply us with an SPD and state that that functions as the master plan document as well. Sometimes that's the case, but it definitely should be looked at a little bit deeper to make sure that that is in fact true. The fastest way to confirm is just to look at the introduction of the SPD. If there's reference to a separate plan document, wrap document, or other document that is governing over the document that you have, you know you're missing something and you need to be looking at this a little further. A Form 5500 will be the next place that I look. It will typically indicate whether or not the plan contains more than just medical coverage. If there are other benefits such as disability or vision or dental wrapped up into a single welfare benefit plan with the medical coverage, then a SPD specific only to the medical coverage cannot logically function as the master plan document for the entire welfare benefit plan. The SPD can serve as the plan document, but only typically if the medical coverage is separated out into its own plan. I'm including here a example of what a lot of legal plan documents would look like. There's no specific reference to any claims administrator. They're very plain. They look very much like a legal document. These documents are maintained by the employer and not a separate vendor. I'm also including a section of the SPD for this plan to show what it looks like in the introduction when there is reference to a separate governing document outside the SPD.
Once we've confirmed that we're reviewing the correct governing document, the analysis then turns to the actual reimbursement language. Nikki, what provisions and issues should the attorneys be looking for when they're reviewing this plan language?
When I'm comfortable that I have the correct governing documents, the next step is to really dig into that subrogation and reimbursement language. to determine what that plan's rights are. And this is a very important part of the process because that contract is what gives the plan their rights of recovery. So obviously, you're going to be looking for any weakness, deficiency, or issues that you could potentially leverage to try to get that lien reduced. One of the first things that I look for is, does the plan even have a right of reimbursement? I know this seems pretty simple, but we've seen over and over again where these plans only have a right of subrogation and not reimbursement. Those are two different concepts. So, does the plan even have a right to seek reimbursement from their member when a settlement's been received? That can really be strong leverage for you if it doesn't. Obviously, if they do have a right of reimbursement, you're looking to see how broad that right is. So you're going to be looking for those equitable doctrines. Does the language address made whole? Does the language address common fund? Does it say the plan can recover as a first priority right? Does it address comparative fault? All of those things can really impact whether the plan gets to recover 100% or not. I also look at how the plan defines recoverable funds. So, does it apply to any recovery or is it limited to recoveries from a third party? So, does it specifically say the plan can recover from or UIM settlements or other types of recoveries? Those details can really make a difference depending on the facts of the case. Finally, I always check whether the reimbursement language is clear and consistent throughout the governing documents. Sometimes you'll find conflicting provisions or language that's missing altogether, and those issues can create opportunities to challenge the plan's reimbursement claim or to negotiate a better result.
This review of the plan language becomes especially important when a vendor only sends a paragraph or a few selected pages, and then they claim that the plan is entitled to full reimbursement. So Justin, how can an attorney verify whether that assertion is accurate, particularly when they know that their state law allows for the common fund doctrine and that there should be some reductions to the lien claim?
A great question. And my answer to that is it all depends on the plan language. First, confirm the ERISA plan is actually self-funded. Review the plan document or the summary plan description provided by the plan's representative, not just the snippet. This can be found in the ERISA or ERISA rights section. Next, check the funding portion. In our example here, we see that it states that the plan is self-funded and contributions are paid from the employer's general assets. Next, take a look at the reimbursement rights, confirming that they in fact have the right of reimbursement, not just subrogation, or any rights at all. We see in our example that this language document claims first priority of full reimbursement. Regarding your question on common fund, you can see here that this plan clearly disavows it in the highlighted portion. Do not rely solely on the vendor's assertions of entitlement. A plan's claim of model or perfect language must be verified against the actual governing documents, not just the summary. Some vendors will argue entitlements on fully insured plans, but there's a reason why you want to bring us on board with your case. We go a step further. We send a 1024B request to obtain the wrapper master plan document, Form 5500, plan amendments, or other relevant governing documents. We conduct a comprehensive document review. We analyze those documents for conflicts or inconsistencies, missing or incomplete provisions, amendment issues, discretionary language that may allow for a reduction, and whether the plan language actually supports full reimbursement claim. We review the controlling language, not just the summary. Just as a reminder, U.S. Airways v. McCutcheon reinforced that the ERISA self-funded plan's actual language controls how it is written. So it is critical to determine whether the governing documents clearly disavow equitable doctrines, such as common fund and made whole, or whether those doctrines may still apply because the plan language is silent or insufficient. The bottom line is plan's entitlement to 100% reimbursement must be supported by governing plan documents, not simply by the plan's assertion or their snippet. Subrogation vendors will cite McCutcheon, but the real question is whether the controlling plan language actually proves the rights being claimed.
As Justin just summarized, the answer depends on the governing language and the law that applies. But let's add another common complication that we see. So let's say that the client was found partially at fault for the loss. Karis, how should comparative fault affect the reimbursement analysis?
The health plan should consider a reduction for comparative fault because the plan is subject to the same defenses as its insured. There are two things to remember. First, look at the plan language to determine whether the plan disclaims the insured's negligence. Second, review state law. Comparative negligence rules vary by state. For example, Colorado follows a modified comparative negligence standard, meaning an insured party who is more than 50% at fault cannot recover damages, and the case would have been lost. Many times there is no written proof of the percentage of fault. When that happens, the allocation of fault must be negotiated.
This brings us from legal reductions and other things related to the contract to the claim amount itself, the actual lien statement that gets received. So attorneys often notice that there are charges that appear on these that are completely unrelated to the accident. Why do these unrelated claims end up in the reimbursement demand? And what should counsel be reviewing first, Jessica?
Subrogation and reimbursement vendors often appear to include many unrelated claims because it is in fact their role to identify and recover payments that may be connected to a third-party liability event or a case where medical treatment was paid for by the injured party's health plan. However, the data they receive is often very broad. So many reasons unrelated claims could be on there is because they receive the member's full claims history, not just injury-related claims. The vendor then reviews everything to look for possible related treatment. They do use broad matching algorithms. So many systems flag claims that include dates close to the accident, providers that appear to be for related treatment, diagnosis codes that might relate. They're also trying to avoid missing any recoverable expenses because missing a valid reimbursement claim costs the plan money. The vendors are also generally incentivized to capture all possible related charges first and foremost, and then sort out relevance later. Oftentimes they're looking at medical records that include chronic conditions. So a hospitalization in relation to a car accident, say, could include treatment for diabetes or hypertension or kidney disease. Some diagnosis codes look related when they're not, such like broad conditions, pain, weakness, swelling. So a vendor may initially include those until they've received documentation that confirms whether they are related or not. So a good way to challenge in like these summaries that include unrelated treatment is to obtain a lien itemization which has line by line breakdown, includes all of the dates of service, all diagnosis codes, procedure codes, billed amounts, paid amounts, then review and separate out any accident related treatment, any pre-existing treatment, and any unrelated treatment, and then go from there.
Identifying that the charges are unrelated is just the first step. Once those claims are found to be unrelated, Jasmine, how is it that the attorney should document the dispute and then ultimately persuade that lien holder to remove them and have an accurate lien amount?
In disputing unrelated claims, lien holders will often request additional supporting documentation to justify removal. This is especially frustrating when the claims are clearly for unrelated medical issues. It's even more frustrating when the lien holder has no reason to think they are related to the loss. In most cases, providing the demand or a complaint or even relevant medical records is sufficient to demonstrate that the services were for unrelated conditions or fall outside the treatment scope. While some lien holders may still push back, the goal is to use the available documentation to demonstrate that the charges are not connected to the underlying case. Ultimately, the focus should remain on clearly showing that the services are not tied to the settlement and demanding that the lien holder remove them from the alleged interest.
So after the claim amount and the governing rights on whether it's state law or the plan language have been evaluated, it's the timing that becomes the next strategic question. So Laura, can an ERISA lien be resolved before the underlying personal injury case settles? Is that something that we recommend?
Whether an ERISA lien can be negotiated prior to settlement is somewhat of a nuanced question. The answer is going to depend on the specific facts and circumstances of each case. However, as a general rule, it is typically most effective to wait until settlement has been finalized before attempting to negotiate the lien. For ERISA self-funded plans, equitable defenses such as common fund and made whole doctrine are generally preempted, provided that the plan language supports that position. Today, we see that most of these ERISA plans do contain language that disavows any sort of reduction, equitable doctrines, and that strongly favors the plan's reimbursement rights. As a result, lien holders are typically going to require the settlement details before they will evaluate whether a reduction is warranted, and if so, the extent of any reduction that may be provided. When a lien holder is asked to reduce its lien prior to settlement or before, there's a top offer on the table, the request is generally denied outright. The lien holder will take the position that since they don't know the settlement, they have to assume that the injured party or insured will ultimately receive a substantial windfall and are therefore unwilling to consider reduction. Obviously, that might not be correct, but that is generally the position they take. Even when a lien holder is open to pre-settlement negotiations, it will often take a firm position and negotiate on the terms that are more favorable for the plan. For example, the lien holder may propose a sliding scale reduction, which would be that they agree to reduce the lien by a certain percentage if the case settles within a specified range. Obviously, this approach can provide some sort of certainty or predictability when resolving the claim. However, it also might limit future negotiation opportunities by effectively capping the potential reduction and restricting the ability to present a stronger argument for hardship after the settlement amount is known. That said, this is only a general guideline. Every case should be evaluated on its own merits. And if a settlement offer has already been made and is likely going to be the top offer to resolve the claim, we can often negotiate based on a proposed amount as though it were the final settlement.
Gotcha. So pre-settlement negotiation may be possible, but it's not always the best leverage point. Brenna, can the personal injury case still settle before the ERISA lien has been finalized? What if you're just waiting forever for that subrogation vendor?
Absolutely. Many cases settle before the ERISA lien is finalized, but really the important thing is not to wait until settlement to start thinking about the lien. By evaluating it early on, we can understand the plan's potential reimbursement rights. We can identify any issues and develop a strategy before it's time to distribute the settlement funds. This proactive approach helps avoid surprises and keeps the case moving towards smoother resolution.
Let's move on to something that we don't see very often, but we do see it. So Mara, what should council do if the health plan or the employer benefit group threatens to retract payments or terminate the health benefits unless the claim is reimbursed in full? Can the plan actually do that?
We most often see this argument from lien holders representing union plans, although other plans will make the argument. These plans are self-funded ERISA and generally include very strong and specific language with regard to subrogation and reimbursement. When a lien holder threatens to retract or recoup payments or terminate benefits, it's important to review the language of the health plan, specifically the subrogation and reimbursement provision, to confirm the plan has granted the right to do so. Here's an example of a provision granting these rights to the plan. If the plan language does not specifically grant the rights to retract, recoup, or terminate benefits, to do so would potentially violate the terms of the health plan contract. If the plan language grants these rights, it doesn't mean the lien can't be reduced or compromised depending on the circumstances of the settlement, but does provide the lien holder leverage, and it is important to consider the possibility when determining negotiation strategy.
That answer, again, comes back to the specific plan language, which is why it's so important to make sure that you have it and then you have all the different varieties that might come with it and that you're looking at the right one. So Morgan, let's consider a different complication. What happens if the plan changes from self-funded to fully insured in the middle of the year? how should the plan's rights then be determined? This is another thing that we see from time to time.
The plan changes from self-funded to fully insured. The plan's rights would depend on when the claims actually took place. For example, if the accident occurred April 1st and the plan became fully insured on June 1st, any claims that the plan had paid incurred from the date of the accident through May 31st would be governed by the self-funded plan. Any claims that took place after that date would be under the fully insured plan. It's really important to see when the claims took place to determine which plan they would fall under. If they fall under both plans, any subrogation or reimbursement negotiations would be based on when the claims took place. So in this instance, if we did have claims taking place on two different plans, the lien holder may have two different files that need to be opened up, but we would base our negotiations on when those claims took place. So some may be subject to state law, and the others may be subject under the terms under the ERISA plan.
So we have covered the legal framework, we've covered the documents, we've talked about some negotiation issues and the claim summaries. So to close out this discussion, Nikki, what reoccurring tactics do you see from the subrogation vendors and carriers? And how is it that attorneys should respond to them when they see them?
Every vendor and carrier handles things a little bit differently. So, there really isn't a one size fits all approach, but we certainly see some common tactics and challenges across the board with all vendors. The number one issue that I see is incomplete documentation. So, a lot of times the vendor is just sending the SPD, or they're only providing the subrogation and reimbursement section. In that situation, we really need the full document to be able to verify that it's the correct document. Also, we don't just want the SPD; we want the governing plan document as well. So this is something that you should definitely challenge. Without the full governing plan documents, you really cannot assess the scope of the plan's rights without it. Another common issue is lien accuracy. We see situations all the time where claims get added to the lien balance without any supporting documentation, and then there's resistance from the lien holder to remove those charges that you may raise as unrelated. In those situations, it's really important to force the lien holder to substantiate what claims they're seeking to recover on. They should be able to prove that the charges are accident related, and the onus is on them to substantiate that. Delayed responses and canned responses is also common. So you can spend a lot of time putting together a very well drafted or detailed argument only to receive a form letter response or a generic response that doesn't even address the issues that you've raised. So really pushing them to provide a specific response to the issues that you've raised. Maybe it takes getting it escalated to their legal team to address, but really forcing them to address the issues is something that you would want to do. Discretion can be another hurdle. So even when there's clear issues with the case, maybe there's some liability issues, limited recovery, collectability issues, hardship factors. Some vendors just take the position that they simply won't make discretionary reductions. And this is something to fight them on. At the end of the day, if you're dealing with a self-funded ERISA plan, it is the plan's discretion to decide whether they reduce or not. So, these vendors like Rawlings or Conduent or Optum, they are looking out for their interest as well. So sometimes pushing it to get in front of someone at the plan, can be helpful. Lastly, we often see vendors that rely on federal law as a blanket justification for their position without, really explaining how that law actually applies to the facts of the case or addressing the arguments that have been presented. So when that happens, trying to get that to their legal team can sometimes lead to a more, meaningful or productive conversation. All that said, there's a lot of tactics that these vendors use, and really the best way to overcome these is to be prepared, stay persistent, really understand the plan language, identifying weaknesses or inconsistencies, making sure their lien is accurate, and presenting supported arguments. That gives you the best chance of getting some movement towards a reasonable resolution.
All right, well, we are here for the live part of the Q&A, and you guys are lighting up the chat. So we are going to answer as many of these live as we possibly can. But as Amanda wrote here on this last message, if we don't have time, we will reach out to you separately and get you an answer. We also do consults. So if you have specific case questions, our phone number will be here at the end, or if you've got a designated sales leader that you normally work with, you can reach out to them and we can help you out on your individual cases as well. So I know a lot of the questions that were coming up here were about the Form 5500. And so let's talk about that a little bit more in detail. Nikki, do you want to cover that part about the 5500?
Yes, I can cover that. So, I did go into a little bit more detail about the funding status, specifically that Section 9, where it lists how their employer-sponsored benefits are funded. What you really want to be looking at, though, is the schedules. There should be Schedule A's attached to the Form 5500. And that's going to provide you some additional context surrounding the funding arrangement. Now, this isn't a slam dunk. This isn't a guaranteed way to determine funding, but it gives you some indicators. So Schedule A's are for those benefits that are fully insured. So fully insured benefits are going to be listed on a Schedule A. So if you're looking at a Form 5500, and let's use Aetna as an example. If the client's coverage is through Aetna, they're claiming it's a self-funded plan. But when you look at the Schedule A, you see Aetna listed as a carrier, and it's for the health benefit plan. Then that's an indication that it could be a fully insured plan, and that's something that you could certainly challenge the lien holder on. So you're looking at that Schedule A to see what carriers are listed for their fully insured plans. The Schedule Cs are what the plan uses to identify their self-funded arrangements. So now I will say Schedule Cs are not required. So plans do not have to file Schedule Cs with their Form 5500. They often do, but this is where you're going to see the self-funded plans listed. So, looking kind of at all the things when you're reviewing a Form 5500, it's not one specific thing that you're going to determine funding. You're kind of looking at various things to give you some indicators.
Yeah, and really those Form 5500s, they aren't related to ERISA reimbursement or all of this. It's just a supplemental thing that we're able to look to as an indicator. So it's not a slam dunk, like Nikki said, on the front end. But if there is information there that supports your position or challenges theirs, you definitely want to use it. So it can be a good tool. So speaking of the plan language, another question we've got here is, if the employer plan administrator doesn't respond to the request in 30 days, there's a daily penalty. Is it proper to apply the penalty as a reduction to the lien for each day late? Kevin, you got that one?
Yeah, so practically you can try that, but functionally it's different. The penalty claim against the plan for failure to provide documents is actually a separate claim under ERISA. So actually to enforce it, you would have to file your own federal lawsuit. So just because they have penalties, it doesn't automatically reduce the lien, though it can be a negotiation point to get the lien reduced. But from a legal standpoint, they are completely separate, different claims. So one doesn't reduce the other. And depending on the vendor, it depends on how much they actually pay attention to that. So some vendors are not so scared of that, other ones are. But technically, it's two completely distinct legal claims under ERISA.
Yeah, definitely. I think in the past, we saw that subro vendors cared more about this if their client wasn't responsive according to that ERISA statute. Now they just haven't seen much of a bite that comes of it. So they might reduce a little bit, but they're certainly not reducing the daily rate. Like Kevin said, you do then have to like actually go file your own action that it's completely separate from the actual lien reimbursement. So it's not a dollar for dollar reduction, unfortunately. Kevin, I'm going to go back to you about a priority issue. So I see two back-to-back questions about those. In Arizona, who has priority in lien reimbursement when there is an ERISA lien and a hospital perfected lien with limited recovery?
Okay. Yeah, I'm going to assume that's an ERISA self-funded plan with rights on that question. The true answer is it's unsettled. I would argue generally going back to what we talked about some of ERISA preemption, that it doesn't preempt any state law, but it does preempt any state law regulation, whatever that would relate to a benefit plan. So my argument, if I was to make one, would be that the Arizona statute is not giving the hospital lien rights is not actually preempted by ERISA. And that it would be the priority lien because it's not the Arizona lien statute doesn't do anything about regulating ERISA self-funded health plans or their benefits or anything like that. So I would argue that the Arizona statute does not relate to a benefit plan, is therefore not preempted by ERISA. But there's no case law on that I know of. It's unsettled across the country in a lot of these cases. And I know there was a larger question about when there's multiple ones claiming first priority. Well, generally Medicare is going to be top dog. Then you're going to have them followed by Medicaid. And then after that is where it gets a little interesting about who actually is the priority lien. The reason Medicare has priority over Medicaid is because CMS is a claim by the United States, whereas a Medicaid lien is a claim by the state, whichever particular state. Just want to make that clear.
Yeah, I think, Kevin, what you just said too is, so much of this lien world has an it depends attached to it because it's unsettled, the unsettled law, right? Like as it relates to it. So we on the plaintiff side can have our positioning. They on the health insurance reimbursement side have their own positioning, and there's very little actual case law or literal statute related to these ERISA self-funded plans that really provides guidance. So that's where it kind of just becomes a battleground and a compromise. Now, the issue is these subro vendors feel really, really strong, and they are trained to believe that their position is 100%. And that's what they want you to believe. But really, as far as them being able to provide support, they're going to provide you some kind of generic thing that really doesn't even say what they're trying to say that it says. So don't be discouraged by that. Now, meanwhile, we don't have a lot to fight back with either in a lot of these situations. But that's where on these ERISA self-funded plans, the policy language is the key all the way around. So that's why we spend a lot of time focusing on it on the earlier Q&A that we did. So let's see, transitioning to another question. Nikki and Kevin, Jasmine, does anyone see one that they want to jump into?
See a number of questions.
When they provide a lien ledger, do they have to independently provide HCFA forms or substantiate billing records?
Not to my knowledge, actually. At Rawlings, I used to work for Rawlings, we would refer to them as FAKEFAs because Rawlings had a system to just generate basically what looked like those types of forms and send them out. I don't think, to my knowledge, there's no requirement that those be provided.
I think we might be having technical difficulties all around. So that's unfortunate. I know we have a minute or less left here in the webinar timing. Tons of questions. I see that I still have 11 new messages that have come in that I haven't even had a chance to look at. So we are going to gather all of these questions. We are going to formulate responses. If after you get them, you want to talk more, you'll have our contact information and you can certainly reach out to us independently of whatever interaction we have with you here as well. So I think I'm going to go ahead and call it because I see that Nikki dropped, and as I understand it, I'm a little jittery on my sound as well, but hopefully all is well on your end, and we'll be working together here shortly. All right, so we have reached the end of our Q&A session. I want to thank each and every one of our panelists for sharing their experiences and their practical guidance. Thank you to all who are watching as well. The central takeaway here is that an ERISA reimbursement demand should never just be accepted on its face value. You've got to do your legwork. So funding status, the governing documents, making sure that the claims are accurate, really digging into that plan language or understanding what law might apply. And then, of course, your settlement circumstances as well. Now, if your firm would like assistance evaluating or resolving these claims, Synergy's lien resolution team is here to help. And thank you for joining us.
Hi, this is Jason Lazarus, founder of Synergy. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families, and freeing trial lawyers and their firms to focus on what they do best. We all care about this mission deeply. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform the efficiency and profitability of your practice.